Yes.
Wait, please, Your Lordship. Lordship, I beg to mention item number 6 can be taken by true Lordship, if possible, Lordship.
6.
Yes, Lordship. Lordship, I have another prayer for item number 8. I am not an engaged counsel in this case, Lordship. The engaged counsel, Swapan Sarkar, Lordship, he is out of station for his treatment at Bangalore, Lordship. May I pray he will come after 10 days. May I pray, Lordship, let this matter come up after 2 weeks, Lordship. In item number 8.
Both sides are represented. Mr. B. Chaudhary, Learned Counsel, appears on behalf of Mr. S. Sarkar, Learned Counsel for the petitioner, and prays for adjournment on the ground that he is out of station for treatment. All the respondents are represented. Next please. List on the date after 2 weeks.
Highly obliged.
Yes.
Please, Your Lordship, I'm sorry to mention item number 13, though it's a matter of 2019. But, my lord, we have received affidavit in 2025. And, my lord, I have noted letter to the Mizoram, the clients, my lord. My lord, some instruction is awaited. There is no stay order prevailing over here.
You have informed the other side. Oh, you are there.
Understand.
Okay.
13-1-3.
Okay. On the prayer made by Mr. P. K. Roy Chaudhary, Learned Counsel for the petitioner, the matter stands adjourned today. P. Bhattacharya, Learned Additional Advocate General for the state of Mizoram is present. List on after 2 weeks.
My lord,
Give a date after 2 weeks.
Obliged.
problem.
Lordship, I beg to mention item number 5 and 17. We have some personal difficulties, Lordship. So both the matters may pass over for the day,
5 and 17.
5 and 17.
5 and 17. 2 weeks. Okay.
Obliged, Lordship.
Lordship, I beg to mention item number 14, Your Lordship. Lordship may come up this matter after 2 weeks, Your Lordship. 14-1-4.
Okay. Give a date after 2 weeks.
Must oblige.
May it please your lordship, I appear for the petitioner for the item number 16. I pray for the short adjournment as my senior is out of station.
It's a review petition. Please wait till the matter is called. Oh, 11 days in advance. Okay. So that is it, right? On the prayer made by Learned Counsel for the petitioner. Matter stands adjourned today. List on. Give a date after 2 weeks.
Item 1 for admission.
May please, Lordships. But actually, this matter was argued on other day. At length it was argued. So far the linkage is concerned with Khandoga Jamaluddin, who is my father. Now, Lordship may kindly see page 24. Miss Saleha Khatun, daughter of Khandoga Jamaluddin. Page 24. Annex 7. So I am Saleha Khatun and my father is Khandoga Jamaluddin, and that is exhibited document. Secondly, Lordship may kindly see page 18. Here, Khandokar Abdul Majid, his name is there in the voter list of 1959. His name is Khandokar Abdul Majid, who is my father. Yes. Yes, yes, those were stated. Now, so far, the linkage is concerned, my lord. In this regard, the president of Bangal Doba Relief Camp Committee, page 27. This is to certify that Mohammad Khandokar Jamaluddin, son of late Khandokar Abdul Majid, an inhabitant of Bangal Doba Relief Camp, Post Office Nayak Gaon PS and District Kokrasar BTAD, his name found in the voter list of 1951, serial number 7, house number 57, under the district Bongaigaon. Miss Saleha Khatun is the daughter of Khandokar Jamaluddin. So this is also an exhibited document. So regarding other witnesses, my lord, one is Praveen Brahma, Chairman VCDC. On the other day, your lordship said that it is not the job of VCDC to issue a certificate. That in this regard, my lord, I have to submit that Section 50 of the Evidence Act. Now perhaps it will be different. So if the VCDC has no work to issue any such certificate, but as a man, he can issue that certificate. Because in Section 50 says that any person who is acquainted or known to the person, he may testify. So he has given the certificate, though it is not his job, but as a man, he has issued the certificate. And this 59 document, voter list, and school certificate, and linkage certificate issued by Secretary Concerned Gaon Panchayat, page 23. Page 23, that was President, and this is Secretaries. Page 23, the Secretary has given the certificate. And page 22, my lord, almost all the family members' names are there. So Abdul Majid, he is Khandokar Abdul Majid. Then Jamal Khandokar, Rashid Jamal it will be. In this way, all are the son of Abdul Majid. Now my father is Jamaluddin, and Jamaluddin's father is Khandokar Abdul Majid. So Khandokar is not written here in page 22. So these are common in voter list. So my lord, the learned tribunal stated that lordship may kindly see page 55, operative portion 97, my lord. 97. Let me see the type copy. Type copy, my lord. Kindly see page 57 onward. Second para 57. The proceeding in her evidence adduced by way of affidavit deposed that she is the daughter of Khandagar Jamaluddin and was born and brought up at village number 2, Sarke Busti of Sarke Busti Gaon Panchayat under Lonka Revenue Circle, Nagaon, Assam, and established a link certificate dated so-and-so, number so-and-so, books number so-and-so, Exhibit 1, to show that she is the daughter of Khandagar Jamaluddin, and that the headmaster of Quran Bijni Batini Ami Madrasa issued her link certificate, Exhibit 2, to show the link with Khandagar Jamaluddin as her father. And she got married to Aizal Haq of village Bangaldova relief camp and produced a certificate, Exhibit 3, to show that she is an inhabitant of village Bangaldova relief camp after marriage. And that Khandagar Abdul Majid is her grandfather, and Khandagar Jamaluddin is her father. Their names appear in the NRC 1951 and exhibited a copy of the NRC 51 as Exhibit 4. The copy of the NRC details marked as Exhibit 5. That the electoral roll of 1966, the name of her grandfather is enrolled as Abdul Majid, A. Majid, and name of her father is enrolled as Basid Jamal, and exhibited a certificate copy of voter list of 1966, which was obtained in the year 1997, Exhibit 6, and that the name of Khandagar Abdul Majid is recorded.
Which page is the Kabin Nama?
Huh?
Kabin Nama.
Kabin Nama. Okay. Can you Kabin Nama ध्यान में रखें?
Not an extended.
Huh?
Annex Quran.
So Kabin Nama, my lord, Kabin Nama is not annexed, but school certificate is there, secretarial Panchayat certificate is there. So linkage has been established. Moreover, 66 voter list, 59 voter list show that their existence in the soil of India is available. Now, Lordship may kindly see the last portion of the order. Last portion of the order, kindly see page 59. 59, bottom. 59 bottom. The official also identified the signature of the document to be his signature. The block development officer of Lambing Development Block, who had countersigned on the linked document, has also specifically disclosed before the court on oath that Exhibit 1 certificate has been issued to him to show that Saleha Khatun is the daughter of Wazir Jamal, and it will be Khandagar Jamaluddin, and that the Exhibit 1 certificate has been tampered to show that Saleha Khatun is the daughter of Khandagar Jamaluddin. The video Tarun Chandra Das filed identifying the signature on document to be his signature has deposed that he has not issued any certificate that Saleha Khatun is daughter of Khandagar Jamaluddin. So this is contradictory statement. He admits his signature, but says that document is tampered. So these are controversial statement, my lord. When he admits that this is my signature, he should take the responsibility that the written Contents are also his own. Now, the last person, Lordship may kindly see, is 62, my lord. Kindly see 62. Fourth para. Now coming to the document number 11, which is an affidavit sworn by on Khandagar Badius Jamal Mia, whom the proceeding claims to be her father, but the name of Khandagar Badius Jamal Mia does not appear in the documents produced by proceeding. Khandagar Badius Jamal Mia is found to be another purported father. Now, my lord, but the name of Khandagar Badius Jamal does not appear in any of the documents. His name is there, my lord. Khandagar Badius Jamal's name is here with little variation. The next para, now coming to the document exhibit A, which is linked document to show that the proceed is the daughter of Khandakar Jamaluddin, the issuing authority of exhibit A linked document DW6 was examined to prove the contents of document. During the examination of the issuing authority of the exhibit A document deposed on oath that the name of the father of Saleh Khatun, the proceeding is Badius Jamal, and that he has issued the certificate exhibit A showing that Saleh Khatun is the daughter of Khandakar Jamaluddin. The own deposition of DW6 is found to be contradictory. The DW6 answering court question further deposed that he is not a government officer and he has not given any authority by the government to issue link certificate. DW6 issuing authority also deposed that he has not issued the link document from the government records. As such, the link document A is not reliable and trustworthy, and document cannot be acted upon, and the link is not proved. Now, Lordship may kindly see the last part of verse 63, first paragraph's last portion. Now, DW5 further deposed that at the time of marriage, Khandakar Badius Jamal was present and is the father of Saleh Khatun. On being examined by the court, DW5 while answering the question put by the court deposed that he does not know if Khandakar Badius Jamal is known by any other name and he has issued the Kabinnama exhibit B as Saleh Khatun is married to, my lord, it may be in record because it is exhibited to Azizul Haq and did not know Saleh Khatun before marriage. As such, exhibit B is not a reliable document. So, my lord, not knowing any person before her marriage, it does not mean that the document which has been issued in her name on the basis of official records is not believable. It does not establish linkage with her father. Moreover, it is only a document to prove marriage with her husband and cannot be acted upon as a linked document. Well, how it is possible? Here in Kabinnama, father's name is there. That is duly exhibited at exhibit 8. And now say that it cannot be accepted as a linkage document. If these types of documents are not believed, how a person can be able to prove his or her citizenship? Apart from the document that have been exhibited and discussed above, the proceeding has failed to produce any other reliable and trustworthy document to prove that she and her parents and grandparents existed in Indian soil prior to 25/3/71. On the other hand, from the materials on record and discussions above, it is found that the proceeding has resorted to falsehood to prove herself as an Indian citizen. Hence, answer it is affirmative, and the SP is directed to take appropriate action. Now, my lord, certain documents have been filed, including NRC and voter list. NRC is not the proof of citizenship, no doubt, as per section 15 of the NRC Act. But voter list is a proof, and linkage is there, school certificate is there. Panchayat and secretary, Panchayat president, secretary has given the certificate. And personal knowledge, PCDG has said that I know she is the daughter of Khandagar Jamaluddin. So these are the documents, this should be believed. The majority of them are public documents. Some documents are private documents, but those should be believed on the ground that the author came and said. So in that view, though private document, but he said got evidentiary value. So the opinion of the learned tribunal, in my humble opinion, does not has the support of law, and order has been passed beyond document, ignoring the document, disbelieving public documents. So, my lord, my humble prayer is that this Saleh Khatan should be declared as Indian by setting aside the order of the learned tribunal. That is my humble prayer. My lord, I have one prayer. I have an item at put number 16. May I go? My junior will be here. Highly obliged, my lord.
Yes.
Lordship, there is no infirmity in the opinion passed by the learned tribunal, Lordship. Here, Lordship, there are mainly three purported projected father of the petitioner, Lordship. And petitioner could not able to establish her link with any of the state person, Lordship. And apart from that, Lordship, the petitioner is totally failed to establish her link with her projected father, whose name reflected in 1966 documents, Lordship. And Lordship, opinion is very much clear, Lordship. Each and every point has been discussed, Lordship. And regarding her place of birth, Lordship, which is very much essential to establish one's linkage, establish one's citizenship, Lordship. That part was contradicted by Prosody herself by giving contradictory statement in WS as well as in evidence, Lordship. And all these things has been discussed in the opinion, Lordship. May I go through, Lordship, opinion?
Yes, yes. So read the relevant part only.
Yes, Lordship. Page 75, Lordship, I am reading. On examining the records, written statement, and the entire evidence and documents produced by the proceeding, it is found that the proceeding during the inquiry could not produce any documents to prove her citizenship. From the facts stated by the proceeding in her written statement and depositions in her evidence on affidavit, it is found that the proceeding has herself contradicted her place of birth. In paragraph 6 of her written statement, the proceeding has stated that she got birth a village Kokila, Mulabipara, Post Office Kokila, Circle Srijan Gram, PS North Salmara District, Goalpara, Assam, and after her birth, she lived in the said village up till her majority, and as such, she is an Indian citizen by birth, whereas at paragraph 2 of her evidence on affidavit, the proceeding deposed that she was born and brought up at village number 2, Sarki Basti of Sarki Basti Gao Panchayat under Lanka Revenue Circle of Nagaon District, Assam. As such, the claim of the proceeding that she is the Indian citizen by birth cannot be accepted to be
true. The proceeding has failed to establish her birth in India. Now, on analysis of documents, it is found that Exhibit 1 is a linked document to show that the proceeding is the daughter of Khandakar Jamal Uddin. The issuing authorities of the linked document were examined to prove the contents of the document. During course of examination on oath, the issuing authorities of the linked document deposed before the court that the linked document Exhibit 1 was issued by them to show that Saleha Khatun, that is proceeding, is the daughter of Bodiruz Jamal. The GP secretary of the Sarki Bosti, Notun Bazar Gao Panchayat, who has issued the linked document Exhibit 1, has specifically deposed before the court on oath that the Exhibit 1 certificate has been issued by him to show that Saleh Khatun is the daughter of Bodiruz Jamal and has been issued by him on verification of the voter ID card of Saleha Khatun and voter list of 2014 of Bodiruz Jamal. The official also identified the signature of the document on the document to be his signature. The block development officer of Lamding Development, who had countersigned on the linked document Exhibit 1, has also specifically deposed before the court on oath that the Exhibit 1 certificate has been issued by him to show that Saleha Khatun is the daughter of Bodiruz Jamal and that the Exhibit 1 certificate has been tempered to show that Saleha Khatun is daughter of Khandakar Jamaluddin. The video Torun Chandra Das, while identifying the signature on the document to be his signature, has deposed that he has not issued any certificate that Saleha Khatun is daughter of Khandakar Jamaluddin and produced the counterfolio of the Exhibit 1 document before the court and stated that the certificate Exhibit 1 produced by Saleha Khatun is a fake document. On examining the counterfolio of the Exhibit 1 document, which is dated 22/7/2015, bearing serial number 2544, it is found that tally with that of the original document Exhibit 1, which also bears the date 22/7/2015 and same serial number 2544. But in the counterfolio of the Exhibit 1 document, it is found that the name of the father of Saleha Khatun is written as Bodiruz Jamal, but in the original certificate Exhibit 1, it is shown as Saleha Khatun, daughter of Khandakar Jamaluddin, which goes to establish that in the linked document Exhibit 1, the name of Bodiruz Jamal has been removed and has been interpolated to show that Saleha Khatun is the daughter of Khandakar Jamaluddin, and as such, it is not a reliable and trustworthy document to prove that Saleha Khatun is the daughter of Khandakar Jamaluddin, and accordingly, the linked document Exhibit 1 being not reliable and trustworthy document, it cannot be acted upon. It is found that the proceeding in order to establish that Khandakar Jamaluddin is her father has resorted falsehood to prove herself as an Indian citizen. Producing false documents itself goes to show that the proceeding is not an Indian citizen but a foreigner. And then Lordship Exhibit 2 also discussed, Lordship, totally. Now coming to the document Exhibit 2, which is a school certificate issued from the school on 2011-2015, showing that Saleha Khatun is the daughter of Khandakar Jamaluddin of village Puran Bijni. Here village is different, Lordship, in school certificate. But as there has already been an interpolation of the name of father of the proceeding in the document Exhibit 1, the document Exhibit 2 is not a reliable and trustworthy document to show that the proceeding is the daughter of Khandakar Jamaluddin and as such cannot be acted upon. Moreover, name of village is also different. Now coming to the document Exhibit 3, which is a certificate to show that proceeding is the wife of Muhammad Azizul Haq and an inhabitant of village Bangaldoba relief camp, as it is a document to show link between husband and wife not proved by examining the issuing authority. It is not admissible in evidence and has also no relevancy in the case and cannot be acted upon. Now coming to the document Exhibit 4, which is a copy of NRC 1951 showing the names of Khandakar Abdul Majid, Khandakar Jamaluddin, whom the proceeding has projected as her grandfather and father respectively. But as the said document is a mutilated and incomplete document and not showing the age of Khondokar Abdul Majid and Khondokar Jamaluddin, it is not admissible in evidence under the Evidence Act and cannot be acted upon. Now coming to the document marked as Exhibit 5, which is a photocopy of NRC. So Lordship, NRC is not admissible in evidence. Then Exhibit 5, also NRC, Lordship. Then now coming page 84, Lordship. Second para. Now coming to the voter list of 1966. Exhibit 6 and voter list of 1970, Exhibit 8, by which proceeding claims that the name of serial number 90 of voter list of 1966 and the name of serial number 90 of voter list of 1970 is that of her father, but it is found that the name appearing at serial number 90 of the voter list of 1966 is that of one Basat Jamal. And the name appearing in serial number 90 of the voter list of 1970 is that of Rashid Jamal. The name of Khondokar Jamaluddin, whom proceeding claims to be her father, is not found in any of the voter list of 1966 and 1970. And there is no explanation to it. It is found that the voter list of 1966 Exhibit 6 and voter list of 1970 Exhibit 8 belong to two different persons, whom proceeding has projected as her father to prove her Indian citizenship. Hence, the voter list of 1966 and voter list of 1970 are not reliable and trustworthy documents and cannot be acted upon to decide the citizenship of proceeding. Now coming to document marked as Exhibit 7, which is photocopy of the voter list of 1959 and is not admissible in evidence under the Evidence Act and cannot be acted upon. Now, then Lordship held it Exhibit 9. It is a post 71 document. So it was rejected by the tribunal. Then Exhibit 10.
What is the ground of rejecting Exhibit 9?
Shall deed, Lordship.
Is it?
Exhibit 9, which is a shell deed of the year 1970. Being a post 71 document, it is no relevancy in the case. Now coming to the document of Exhibit 10, which is a document of the year 2010 in the name of Bodiot Jamal. Here again name is Sanjit Lordship in 2010 voter list, whom the proceeding claims to be that of her father. It is found that Bodiot Jamal is another purported father of the proceeding. The document Exhibit 10 is not reliable document and cannot be acted upon. Now coming to the document Exhibit 11, which is an affidavit sworn by the Khondokar Bodiot Jamal Mia, whom the proceeding claims to be her father. And my lord, in this affidavit, projected father of the proceeding, not stated that Lordship he is Khondokar Jamaluddin Lordship. He sworn his affidavit as Bodiot Jamal Lordship, whose name is nowhere in earlier pre-71 documents Lordship. Now coming to the which is affidavit sworn by the Khondokar Bodiot Jamal Mia, whom the proceeding claims to be her father, but the name of Khondokar Bodiot Jamal Mia does not appear in any of the documents produced by the proceeding. Khondokar Bodiot Jamal Mia is found to be another purported father of the proceeding, and hence the documents Exhibit 11 is not reliable document and cannot be acted upon. Now coming to the document Exhibit 8, which is a linked document to show that proceeding is the daughter of Khondokar Jamaluddin. The issuing authority of Exhibit A linked document DW6 was examined to prove that contents of the document during examination during examination of the issuing authority of Exhibit A document deposed on oath that the name of father of the Saleha Khatun, that is proceeding, is Bodiot Jamal, and that he has issued the certificate Exhibit A showing that Saleha Khatun is the daughter of Khondokar Jamaluddin. The own deposition of DW6 is found to be contradictory. The DW6 answering answering the court question, further deposed that he is not a government officer and he has not been given any authority to the government to issue link certificate. DW6 issuing authority also deposed that he has not issued the link document Exhibit A from any government records. As such, the link document Exhibit A is not a reliable and trustworthy document and cannot be acted upon, and the link is not proved. Now coming to the document Exhibit B, which is a registered Kabinnama issued on 18/1/2001, by which the proceedee wants to show that she is the daughter of Khandakar Bodiuz Zaman and got married to Azizul Haq and has used the Exhibit B document as a link document. The name of the village of the proceedee in Exhibit B document does not tally with the name of the village of the proceedee in the other documents. On being examined on oath, the DW5 who issued the Kabinnama Exhibit B could not produce his original.
Please read that again. I missed it out last part. That
Regarding
name-
Kabinnama.
Yes,
No, sir.
that name does not tally. Please
Yes.
repeat that again.
Exhibit B document is the name of village of the proceedee in the Exhibit B document does not tell you the name of the village of the proceedee in the other documents.
This is the Kabinnama.
Yes. Married lot. On being examined on oath, the DW5 who issued the Kabinnama Exhibit B could not produce his original appointment order as Qazi. On being examined, the DW5 further deposed that his authorized agent performed the marriage. But the proceedee did not examine the authorized agent. The DW5 further deposed that at the time of the marriage, Khandakar Bodiuz Zaman was present. He did not say that is Khandakar Jamaluddin was present during the time of marriage, lordship. And is the father of Saleha Khatun. On being examined by the court, the DW5, while answering to the questions put by the court, deposed that he does not know the Khandakar Bodiuz Zaman is known by any other name, and he has issued the Kabinnama Exhibit B as Saleha Khatun is married to Azizul Haq and he did not know Saleha Khatun before marriage. As such, the Exhibit B is not a reliable document to establish a link by the proceedee with her father. Moreover, it is only a document to prove marriage with her husband and cannot be acted upon as a linked document. So, Lordship, these are the exhibited documents discussed, Lordship. And after that, tribunal come to the conclusion that proceeding could not able to establish her link with her projected father whose who whose name enlisted in the voter list of 1966 or whose presence is here since 1966, Lordship. And Lordship, regarding that, 2017 4 GLT 346, Lordship. Rosminara Begum's case, I'm again relying here, Lordship, in para 31 and 32, Lordship. The High Court relying on the, yes, Lordship, 2017 4 GLT 346.
Oh, GLT 346,
Yes, Lordship.
para,
Para 31 and 32. Here in these two para, Lordship, the Supreme Court's decision has been relied by the Honorable High Court and accepted the settled position settled by the Honorable Supreme Court, Lordship. Paragraph 31, Lordship, may I read?
yes.
Law on this aspect is very clear. In Narmada Devi Gupta versus Birendra Kumar Jaiswal, 2003, 8 SCC 745. Supreme Court reiterated the legal position that marking of a document as exhibits and their proof are two different legal concepts. Mere production and marking of a document as exhibit cannot be held to be due proof of its contents. Each execution has to be proved by admissible evidence, that is, by the evidence of those persons who can vouch for the truth of the facts in issue. Para 32, this proposition was again reiterated by the Supreme Court in LIC versus Rampal Singh Vissen in 2010 for SSC 491, wherein it has been held that mere admission of a document in evidence does not amount to its proof. In other words, mere marking of exhibit on a document does not dispense with the proof which is required to be done in accordance with law. Under the law of evidence, it is necessary that contents of documents are required to be proved either by primary or by secondary evidence. At the most, admission of document may amount to admission of its contents, but not its truth. Contents of documents cannot be proved by merely filing in a court. Such a document cannot be relied upon. So, Lordship, proceeding exhibited so many documents, Lordship, but Lordship, vital documents exhibit 1, Lordship, it was tempered, Lordship. So, and Lordship, it is settled law that Lordship appreciate everything, Lordship. So, my humble submission is that Lordship, there is no infirmity in the opinion. So, Lordship, opinion may not be disturbed, Lordship.
They're referring to 5 witnesses.
Yes, Lordship. I think Lordship 6 is necessary. Total 5 witnesses. Total 5 witnesses. Total 5 witnesses, Lordship.
As per the impugn opinion, was any evidence expunged?
Lordship, it was not in this Lordship. Not Lordship. No, no Lordship.
Huh?
Not that.
Mm, PPR 15. President Pangalina repeat camp.
Yeah, so probably he did it. Exactly.
Yes, Lordship.
In the opinion, is the names given of the witnesses?
Yes, Lordship. In exhibit one, two witnesses deposed, Lordship. I think, Lordship.
No, it show you the records. Just, Mr. Sharma, just pass it on for a moment. My sister has a query.
Here, Lordship, GP
Just-
Secretary.
Wait, same day. Krishna with his same-
DP Secretary and video Lord.
Let's go. Keep it. No, yes. It's it. It's exhibit one. It. Exhibit. Take one and discuss. Make the piece, but don't take. Yep. The next second in the chat. Just a second. Thank you. You could do it. Yeah, and how they. Exhibit. Exhibit 7. Exhibit 6. Five. Alright. Exhibit 6. Right. Because of your and here I'm going to tell you. Exhibit is this certificate. Well. Right, but has been like. Execute one to take the what? It's what is it? You have to say that. So certificate exhibit one produced by Sadia company is a part of. So the exhibit one, exhibit two. The school certificate. So exhibit 3. Is certificate to show that is the right of people. Yes.
Yes, Lordship, total 6 witness, Lordship. I could find Lordship, total 6 witness.
6 witnesses.
Yes, Lordship, in exhibit 1, Lordship, 2 witnesses come and depose, Lordship. GP secretary and BDO. Okay.
See this. See page 198.
Yes, DW.
Turn that page. There's an exhibit there after one page.
Which is
You've seen the exhibit.
Yes,
You've
sir.
seen the exhibit.
Coming number,
No, see that continuation, page 3, 2 or 3. No, immediately thereafter. Yes, there's an exhibited document.
Exhibit one, PAN card.
Yes. Now come to page 187.
187.
Come to 187.
DW6, Akbar Mia.
Now turn the pages. You have found one exhibit. Two pages of evidence.
Yes,
After that, you will find an exhibited document, back page. You got it?
This application, Doctor. This application.
Yes, it's marked as exhibit.
Yes, Doctor.
Correct.
Okay, yeah.
Now turn the next page. Again, one exhibit.
Yes, Doctor.
Correct.
Yes.
Turn page. Again, one exhibit. Correct. So two exhibits here. One exhibit in the earlier deposition.
Hmm.
Now, these two depositions are taken on 25/5/16. Look
Yes,
at the order sheet. 25/5/16.
Yes, Doctor. Evidence of procedure is concluded and closed. For argument. Six for argument, Doctor.
So where is the reference to these witnesses? Where is the reference to those exhibited documents in the opinion? Rather in the bench, we wanted to thank everyone who don't read. No, it's not there. All the witnesses we have flagged. All the witnesses we found in the record, we have flagged.
Yes, Doctor.
You see, we want to thank everyone in this case, not everyone in the room. Everyone in this case for not reading, because after this 195, 198, you will also find a written argument. Even in that written argument filed by the petitioner, this were not taken into account.
Yes.
So not even the trial court, even in this writ petition, nobody is reading the records. And we really appreciate. It gives us an upper hand. We can do whatever we want now.
Otherwise, Lordship, I think Lordship. Lordship, this will not prejudice to the proceeding in
Hmm?
a way, Lord. This will not prejudice to the proceeding, Lordship. Regarding.
The question of prejudice is not there. We are not even there on prejudice. We are in fact thanking everyone for not reading. That person. And he sent back the file. Just say. The submissions of Mr. Amir Mahmood and counsel for the petitioner, as well as of Swenso for the respondents, I concluded, judgment reserved.
Item 2.
Writ petition. Thank you. Yes, Mr. Mandal.
Yes, may I please, Lord. My Lord, here, Lord, impugned order, Lordship will find at page 38. And findings, my Lord, basically started at page 40, para 5, my Lord. Page 40, para 5. Para 5, may I read, my Lord?
Yes.
But para 5. I have gone through the, I have carefully gone through the and perused the documents laid upon and executed by the OP. Therein are also threadbare scrutinized the same. 1. Exhibit 1 is the certified copy of the voter list of 1966, wherein, as per the OP, her grandfather's name is recorded at serial number 42 as Imtaz Ali Kubras, son of Jamon, aged about 48 years. And at serial number 44, the OP's grandmother's name is recorded as Shukuron, wife of Imtaz, aged about 46 years, being the residents of the village of Chugijan, PS Hosai under 92, Jomunamo Kalesi. The OP DW1 in her close stated that her grandparents' name was Imtaz Ali Kubras and her grandmother's name was Shakiron Begum. However, in Exhibit 1, although the grandfather name is correctly recorded, yet her grandmother's name is not correctly recorded as Shakiron Begum instead of Shukuron. Moreover, the OPDW1 has nowhere mentioned in the evidence as to why between serial number 42 and 44, the serial number 43 is missing, and or as to whose name may be there at serial number 43. That apart, in exhibit OPs, the grandfather is mentioned 48 years and her grandmother says 46 years. In her cross, it is submitted by the OP DW1 that her father had expired in the year 2003 in the age of 60 years. If so, then her father's year of birth and whole sometimes 1943. His age is 1966, 23 years, but the OPDW did not mention anywhere in her evidence as to why his father's name did not appear in the voter list of 1966. Exhibit 2 is the certified copy of the voter list of 1970, in which serial number 19 thereof, the grandfather's name of OP has mentioned as Imtaz Ali Kubras, son of Jamon, as at 72 years in 1970. However, at serial number 21, the name of the OP's grandmother is mentioned as Chukuron, wife of Imtaz, as at about 25 years, as stated above in respect of Exhibit 1. The grandparents' name of the OP was Shakiron Begum, not Shukuron. Moreover, in Exhibit 1, voter list of 1966, OP's grandfather's age as mentioned 48 years, but his age in the voter list 1970 is mentioned 72 years, almost double to the age of 1966. Similarly, the OP's grandmother's age in the voter list of 1970, Exhibit 2 is mentioned as 25 years, although it was 46 years in the Exhibit 1 voter list of 1966. Such wide variation of ages of the grandparents of the OP, as indicated above, had not been explained and clarified by the OP in the manner in the evidence, in our evidence. Exhibit 1 and 2 being the purported documents exhibited in the protected names, therefore, there is serious doubt about its truthfulness, rendering the same to be untrustworthy and unreliable. Exhibit 3, Exhibit 3 is a residency certificate issued in favor of the OP, herein the Gaubra of the Dobuga town, certifying that the Gaubra knows the office of the case as her name is recorded in the voter list of 2014. In respect of 90, Jomunamo Kalesi, in Exhibit 3, the author of the has nowhere that certificate that the OP was born in the said village, and or as to for how long she has been residing in the said village town. Therefore, this is not a sufficient proof to prove the OP having namely Sabita Begum is a citizen of India by birth. Exhibit 4 is the certified copy of the voter list of 2014, wherein beside the name of the OP, her mother, sister, brother's name are mentioned. There is absolutely no mention in the evidence of the OP DW as to why her own name or parents' name had not been included in any voter list of and or any other official record subsequent to the year 1970, Exhibit 2, and prior to 2014, Exhibit 4, all along 44 years together. The Exhibit 4 being a document of the last years itself, therefore cannot enough to establish a linkage with the documents of the pre-part of the 25/3/1971. Exhibit 5 is the birth certificate issued in the name of the OP, wherein the registered birth and death, Jugijan PS, the said birth certificate was issued to the OP on 24/7/2009.
In which voter list your name of your father appeared first?
Yes. Well, first voter list, my lord, 1966 at page 16. Page 16. Page 16, my lord, Imtiaz Ali, Kobiraj, grandfather.
No, your father's, we are
Yes.
asking,
Father's.
which is the first
also
voter
will
list
find
of your
page
father?
18. Page 18.
Page 18.
18. Imtiaz Ali, grandfather.
No, your father.
Shukur,
Sukur is your father.
father.
Where is?
Then page 20, lordship will find
Just a moment.
voter list of 2014.
No, just a moment. We are. Come back to you, just a moment.
Next page, my lord, 20, voter list of 2014, where her name has been appeared at serial number 821, page 20. Yes. Here, my lord, her father's name has been mentioned Abdul Shukur. And again Shukur Ali. Against her brother's name, Shukur Ali and Abdul Shukur. That is one of the my lord, discrepancy as indicated in the voter list. Then, my lord, birth certificate lordship will find written statement, my lord.
Yes, where is that?
Written statement, my lord, at page 14,
14.
14, 1/4.
Yes,
Yes, page 14, my lord.
yes.
My lord, paragraph 2 says, my lord, that the.
We have read it.
My lord,
We have read in the meantime.
yes. Then, my lord, page 22, birth certificate of the petitioner, my lord.
2009.
Yes, 2009. She was born 12/8/1991.
No, but is there any magisterial order available?
That was not, my lord, available on record as well as in the, my lord, cross examination of the, my lord, petitioner.
Okay,
DW.
did the authority come and depose? No.
Yes, no, my lord, no authority. That has been, my lord, disbelieved by the tribunal itself, saying that since she was born in 1991, certificate was issued in the year 2009, so it was disbelieved. Then, my lord, the Gaubra certificate lordship will find at page 23. That is exhibit 3. In paragraph, my lord, second paragraph, it is say the aforesaid person is Muslim by religion. Her name is appeared in the voter list of 2014 by serial number so and so, house number so and so, center number so and so, name DBA school, and inhabitant of the aforesaid address, and she's well known to me. So this certificate has been issued truly. Then page 25, my lord, the electoral identity card.
Yes.
Then, my lord, her evidence in chief, lordship will find at page 26.
We've seen that.
Yes. Same line has been defined.
We've
Now-
seen that.
Yes, cross part lordship will find at page 28. Cross portion, my lord.
In this 26,
Page
take note
20.
of the fact that in fact, no document is exhibited here.
Yes. In the cross portion, my lord, the document has been exhibited. Page 28.
Yes.
Yes. Now, there, my lord, page 29, last paragraph, my lord, last two line, lordship will find, page 29 of the course portion. No inquiry was conducted by police upon me. I am an Indian citizen by birth, and that is why I am not a foreigner. Then, my lord, page 32, another voter list of 2010, where, my lord, her brothers, sisters, and mother's name appeared. It was prior to 2014, so her name was not appeared. It is 2010. Then, my lord, 2011 voter list is 34. Brother, sister, mother.
Right. One other. Right. Misinterpret করে misinterpret করে কিভাবে দিছে he died in 2003. What is said? But evidence is strange.
Hello.
When given a suggestion that father died in 2003, she says she does not know.
Yes, my lord. Her father had expired in the year 2003.
No. No. You have a cross-examination,
Yes.
which age?
Is 28, my lord.
28. Now come to the SMS version. In the
Page,
middle,
page 30, my lord.
page 30,
Page 30.
in the middle, about 15 lines from below, মোৰ দেউতা 2003 চনত 60 বছৰ মান বয়সত ঢুকাইছিল, মই নাজানো।
Yes, মই নাজানো. Yes, my lord. মোৰ দেউতা 2003 চনত 60 বছৰ মান বয়সত ঢুকাইছিল মই নাজানো
You see, this writ petition was filed in 2016. She was 25. This cross-examination was in 2016. She would be same age. Forget the that 2003. She would be a young girl to forget the death of the father. She creates a discrepancy in the cross-examination with regard to the grandfather and grandfather and grandmother. According to her cross-examination in 1970, that exhibit is not of the entry is not of the father, but it is of the grandmother.
that is the perversity in the
There is-
improvement also
No, there is another thing which is strange. Very rarely it happens that the name of the grandmother and the father would be same.
now father is Mullah Shukur Ali grandmother was Shukuron
Sukur Jan,
Shukurjan
same,
yes but father's name is Shukur
same
Abdul
thing.
Shukur Ali
Normally it doesn't happen in a family. Two people have very similar name. It's very uncommon.
now those are evident from the Mullah certified copy obtained by the petitioner if there is some error in the process of Mullah providing the certified copy she had no role Mullah it's a certified copy
No, you don't write name according to the certified copy. You write the correct name and then say that this is right or this is wrong. Once you accept it in the cross-examination, what remains in the case?
somehow it is Mullah Shukur somehow it is Abdul Shukur somehow it is Mullah
Because-
Shukur
no,
Ali
no. We are not on that. If the grandmother is 25 in 1970,
yes
your father died in 2003 at the age of 60. What is it? When were you born?
No, that
When
is,
will-
that
when
is,
you
that
father
is the
born?
Mullah, that is the Mullah perversity reflected in the impugned judgment. Lordship will find at page 41,
Before
page 41, para 2.
2003, 60 would be 3. 1943. 1966 is 25. But there is no explanation to the discrepancy. Grandmother is born in 1943 and the son is born in 1941. Oh, sorry. Son is born in 43, grandmother born in 41.
Yes, that was
That
one of
is-
the ground, my lord.
That is
No
the only
grounds
ground
of
which
delay.
remains.
Now, page 41, may I, my lord,
41.
page 41.
Yes.
My lord, line number, my lord, 10, paragraph
Yes.
2.
Yes.
Where it's a age of 66, my lord.
Yes.
Then similarly, the OP's grandmother's age. This is, my lord, something, my lord, contrary to the records. In the voter list of 1970, Exhibit 2 is mentioned as 25 years, although it was 46 years in Exhibit 1, voter list of 1960. This is, my lord, not grandfather, it should be, my lord, fathers. This is, my lord, 70 voter list, lordship will find. Voter list of 1970. Lordship will find at page, my lord, 19. Page 19.
Yes.
Shukur. He is the father of the petitioner,
Yes.
not the grandmother.
No, no, no. We have just read your cross-examination. In cross-examination, you demolish this and say that 1970, the second name is of my grandmother. Her age is 25 years. That is what you said. Look at your cross. That's why we read this cross-examination.
Page 31.
My grandmother's name is Shakiron Begum.
Page 31 of Amir.
Please read that.
Page 31.
I would forget. I won't
Exhibit 2.
remember it.
Exhibit 2.
Exhibit 2.
31. Exhibit 2. That Assamese person.
1970. Yet more
Page
Koka
31 man. Exhibit.
ইয়াত মোৰ ককা দেউতাৰ নাম সিৰিয়েল নম্বৰ 19 আছে আৰু ককা আইতাৰ নাম 21 আছে।
Serial number 21.
কাৰ নাম আছে নাজানো।
Yes, in the exhibit 2 itself, clearly written. Exhibit 2 seat in serial number 19, it is my grandfather. Serial number 21 is my grandmother. And my grandmother name has been wrongly spelled as Shukur and age is wrongly said 25 years. Yes. In the cross. You pay it. Nope. Yeah. Yes.
Now another part, my lord, we have filed, my lord, additional affidavit. Lordship will find it was filed on 6/11/2019. Yes. In the, yes. It was filed on, my lord, 6/11/2019 on. Their lordship will find the final NRC at page 5. Her name has appeared. It was in the year 2019, after the judgment and order. Serial number, my lord, 4, Sobita Begum. Yes. Yes, that has been filed. Yes, I will come, my lord. Abdul Shukur. That was says, my lord, if, my lord, anything is, my lord, found, my lord, mechanically, my lord, error in the NRC, that can be rectified. But Now, if my name is my lord, that's true, my lord. Now, at this stage, if my name is deleted from the my lord, final NRC, then I would have the right to file an appeal before the appellate authority. There is a provision. And my lord, another judgment, short order, lordship will find at page 9. Page 9 in identical issue, page 9. Yes, 9 of the additional affidavit, my lord. Lordship has seen the my lord, NRC in continuation, page 9, my lord. My lord, short order, my lord, of the Honorable Apex Court. This being, my lord, learned counsel appearing on behalf of the petitioner has informed us that his name has since been included in the NRC. This being the case, we set aside the impugned orders. It will be open for the learned counsel appearing on behalf of the state of Assam verify this fact, and if found to be incorrect, come back to us. The special leave petition is disposed of accordingly. And another additional affidavit, my lord, filed by the petitioner, only to bring the, my lord, another, my lord, voter list of 1975. It was filed on, my lord, 22/5/2019. Just, my lord, voter list of 1975, which was brought on record by OIB. And my lord, the affidavit of opposition filed by the respondent number 10, it was filed on, my lord, 20/12/2019. That basically, my lord, para 6 of the, my lord, affidavit of opposition they are relying on. Yes. Now, my lord, another affidavit, my lord, we have filed, my lord. Lordship will find that was filed on, my lord, 29th day of August 2023. During the pendency of the panel proceeding, such development has been, my lord, some development has been occurred. Their lordship will find basically, my lord, page, my lord, 112, the inquiry report by the SP, my lord, page 112. Yes. Now, page 113, Lordship will find the relevant portion, my lord. 113. On receipt of documents submitted by Abdul Rahim, son of Imtaz Ali, Kobiraz, Imtaz. Page 113, my lord. Hundred and 12, my lord, it's a, my lord, submission of the inquiry report. Designation, my lord, maybe, my lord, yes. Second page, Lordship will find. On receipt of documents submitted by Abdul Rahim, son of late Imtaz Ali Kobiraz, Imtaz Ali Fakir, village so and so, so and so. It is found that both the documents provided by the OP, Musammad Sobita Begum and Abdul Rahim, and son of Imtaz Ali Kobiraz, Imtaz Ali so and so are same. But Abdul Rahim claimed that both Mokbul is his mother and Shukur of his stepmother. Now here again, Mullah Shukur. Instead of Mullah Shukurun, Shukur has been Mullah treated as his stepmother because his father had two wives. I have collected the certified copy of the voter list of 1966-1970 produced by the OP, namely Sobita Begum, daughter of Abdul Shukur Ali. It is found that both documents were found manipulated in the name of Shukurun and her age, gender and relationship. And it is also clearly mentioned in the voter list that Shukur and Mokbul were the wives of Imtaz. So now another findings come by the SIB, Ipsakur IC border branch. Thus, in view of the above facts and circumstances, the merit of the evidence on the record, it has come to the notice that the OP, namely so and so, our family members has no any connection with the Shukurun and Imtaz Ali, and also notice that they had manipulated voter list of 1966, 1976. Hence, the Shukurun and Shukur were the same person.
Is the significance of this inquiry? How reliable it is on this, for the reliability and and the effect of this inquiry report?
Yes, my lord, it is against the petitioner, but we are, my lord, submitting, my lord, how the different authority in a different times keeps a findings which, my lord, confuse the entire situations.
No, that's
Now,
okay.
Now, my lord, Lordship has seen the certified copy of the voter list
No,
we have obtained,
We are not on the effect of this
my lord,
query is limited to what, according to you,
my lord.
would be the position of this inquiry report.
My lord.
So far as applicability and reliability is concerned.
My lord, we are not relying the, my lord, inquiry report as submitted by the, but we are, my lord, assisting the court. What has been, my lord, done behind me by the respondent authorities from time to time. Now you are saying the voter list is manipulated. Who manipulated? Can it be imagined? Certified copy of the voter list 1966 has been obtained. Now blame came to me saying that it is manipulated. By whom it is manipulated?
That will have to only order arrest of the person taking
Well,
forensic and then.
Yes. If it is really manipulated, can it be, my lord, blame it to the petitioner, my lord, how she had the role in preparing the certified copy? everybody knows the person concerned who applied for the certified copy had no role. Unless it is proof
No,
before the
I
competent
just-
authority.
I'll just pose a question. I am good in posing this uh, very light.
My lord, that's true, my lord, exactly, my lord. Mere saying that has been manipulated. It has to be tested before the court of law. Unless it is tested before the court of law by my lord, adducing evidence, nobody can say it is manipulated. In that case, my lord, every document should be, my lord, fatal in the eye of law. It has to be tested before the court of law. This is my, my lord, humble submission before your lordships, my lord. Though it was, my lord, against the petitioner, I am relying, but I am assisting the court. What has been done, my lord, in the courts of, my lord, proceeding while matter is pending before the Honorable High Court. For that purpose, my lord, I have brought on record. Otherwise, I would be, my lord, blamed. I have suppressed the materials facts in the process of, my lord, proceeding. That must, my lord. And, my lord, so far the, my lord, plea I have taken, my lord, in the writ petition, my lord, that has been, my lord, rendered by the Honorable Apex Court. My lord, in Rohim Ali and Abdul Rohim, my lord. Yes, my lord, they are basically, my lord, the ground of, my lord, region, the ground has to be, my lord, furnished to the petitioners before the case has started. That has been, my lord, narrated. They are particularly, my lord, paragraph 34, paragraph 40, 41, 42, and 44. Paragraph 34, 40, 41, 42, and 44. That's much I am relying, my lord. My lord, we are extremely sorry, my lord, in the, my lord, NRC case, my lord. In the other cases, my lord, we are also relying, my lord. We are having the, my lord, only 2 copies, my lord. It is voluminous, my lord. That is, my lord, writ petition number, my lord, 274/2009. It is Supreme Court, my lord, by judgment and order dated 17/10/2024. Yes. Basically, my lord, there is a separate part, my lord, only, my lord. Yes, page, my lord, 91, my lord. Lordship will find. Page 91, first. That judgment. And again, my lord, yes. Paragraph, my lord, conclusion, D, para 125. Page 91, D, conclusion, para 125. In view of the discussion above, the following are the conclusions. 125. Part D, my lord, it has been, yes, page 91. My lord, page 91. Part D.
Page 91.
Yes. Yes, madam. It one part of 6A. Page 91. It is a part D. Part D. Yes, D. Not para 125, Lordship got it. Para 125. In view of the discussion above, the following are the conclusions. A, Article 6 and 7 of the Constitution of India prescribe a cut-off date for the conferring the citizens of migrants from East and West Pakistan at the commencement of the Constitution, that is 26 January 1950. Section 6A of the Citizenship Act conferred citizenship from 1st January for whose migrated before the date. Those who migrated between 1st January 1966 to 24 March 1971 are conferred citizenship upon the completion of the 10 years from the date of detection of the foreigners. Section 6A confers citizenship from a later date to those who are not covered by Article 6 and 7 of the Constitution. Thus, Section 6 is not violative of Article 6 and 7 of the Constitution of India. It has indeed, my lord. Yes. Up to paragraph G, my lord. Page 93, para G, it is in there. G, Section 6A2 cannot be held unconstitutional for not prescribing a procedure for registration. My lord. Then, my lord, yes, legal.
What is the legal procedure? What is the submission in which you are taking aid of this para 125?
Yes.
What is
Now,
your legal submission in aid of which you are taking help of this?
yes, my lord, I am submitting, my lord, on the basis of the, my lord, apex court judgment. Since the, my lord, NRC has been finalized, that has been categorically upheld by the Honorable Apex Court, saying that the cutoff date would be 1971, 25th of March 1971. The case was, my lord, challenge before the Supreme Court was that the cutoff date should be 1950, 51. That has been, my lord, not accepted by the Honorable Apex Court. And it has been accepted.
What was the ratio down in this case of Abdul Quddus?
Yes.
What does it say? Has Abdul Quddus been diluted by this judgment of 6A?
6A.
What does Abdul Quddus say?
Abdul
Once your name is there in the declared foreigner, then notwithstanding the entries made in the NRC, those facts that would not be given effect to. That is what I remember.
Yes.
But I may be wrong. I have a weak memory.
Yes, that is there. That is there. That is there.
That has been reaffirmed by recently in 2025, another judgment, where it is clearly said, on 2 line, if I may read, 4 line, in view of the decision of the court in Abdul Quddus, relying on that. Firstly, consequent to the declaration by the tribunal.
No, let Mr.
Yes.
Fine, let him complete.
No, that's only for my reference. Yes.
That is the, my lord, only, my lord, purpose we are referring to. Very good.
My submission, your lordship. Firstly, your lordship has seen the WS Malad as well as evidence. In WS para 3 as well as in evidence para 3, it is the pleaded case that the Malad, the father's name and grandfather's name appear in 1966 and 70 voter list. Clearly.
Just a moment.
Para 3 of the WS fund, that is clearly said. And in evidence in para 3, same thing. Grandfather's name and father's name appear as Imtiaz Ali Kabiras and Sukur in 1966 and 70.
Yes.
Now, what evidence? The cross part, my lord, actually, I was relying on the cross part, my lord. Page 28, my lord, right below, my lord. Exhibit 1, what?
That is a page.
Page 28, madam. Particular is page 30, madam.
Can you read the vernacular one?
Yes, we can
You
read the
do-
particular, madam. Page
You would be more
30.
comfortable.
Yes, page 30 will be better, my lord. Only I'm relying this exhibit 1 and 2 because, my lord, what she has stated in the, my lord, WSN evidence that has been contradicted here in the, my lord, cross part. Page 30, exhibit 1, 1966 voter talika, ইয়াত মোৰ ককা দেউতাৰ নাম আৰু ককা আইতাৰ নাম Sukuron Nessa হিসাবে আছে ককা আইতাৰ নাম Sukuron Nessa হিসাবে আছে. That means grandmother's name has been recorded as Sukuron Nessa. Sokiron Begum হিসাবে উল্লেখ নাই. Sokiron Begum is not stated. Serial number 42 and 44. That is to be noted in as the mother exhibit in exhibit serial number 42 and 44, grandfather's name and grandmother's name. That is her statement in the cross. Now exhibit 2, this is better. 1970, 1970. ইয়াত মোৰ ককা দেউতাৰ নাম serial number 19 আছে. 19 আছে ককা আইতাৰ নাম 21 আছে. So if your lordship may kindly see the voter list of my lord 1970, that is my lord page particular is page 19. This is exactly what she has been describing in my lord page 31. In 1970 voter list, her grandfather's name is there in serial number 19. In the voter list of 1970, page 19, and grandmother name is page 21, serial number 21, Sukur. That's it. And serial number 20, কাৰ নাম আছে নাজানো. এইটো স্পষ্ট এই মনত মোৰ ককা আইতাৰ নাম এই সনত মোৰ ককা আইতাৰ নাম grandmother's name Sukur হিচাপে আছে. Has been recorded as Sukur name, Sukur. Sukuron বা Sukuron Begum নাই. Nor it is recorded as Sukuron, neither it is recorded as Sakiron. আৰু ককা আইতাৰ বয়স ককাৰ আইতাৰ বয়স 72 আৰু ককা আইতাৰ বয়স 25 বছৰ লিখা আছে. That's grandfather's name has been 72, age is recorded as 72 years, it is 25 years. So this is clear, my lord. She has contradicted herself with regard to my lord, the voter list of 1966 and 70. Now, the only point is that, my lord, if my lord, why the inquiry has to come out? This matter was before this honorable court while going through, made an inquiry whether this is the Sukur and the Sukur, my lord, is the whose name is voter list in 1970, and this Sukuron. This statement is correct, or the ballot evidence which is given in the written statement and evidence is correct. For that purpose, this inquiry was directed. There, that inquiry has come out. It is only the Sukuron, and Sukuron is the same lady who is the my lord. In fact, who has in that inquiry, even though it cannot be relied on at this moment, that inquiry it is said, my lord, the voter list which is there in 1970 and 66 is not related to this petitioner. That has come up. So I'm not on that, my lord, no, only on merit. It is clearly said, she herself contradicted everything. So now if this is 1960 and 66 and 70 is the voter list of grandmother, where is the document of her father in the name of Shukur, either in the Sukul or in the Abdul Shukur name? There is no documents at all after 1970. Had she have been confirmed this is her father, that's a different issue. But she has said no, it is the grandfather's name. So first of all, she has to establish that her father was a citizen of India. Then she has to bring the link. So that is the simple issue. So there is no document at all of his father. That is on merit. And second issue, my lord, on SOCOS, there are numbers of judgment of this noble court. My lord, the best is, my lord, if I may refer, this WPC number 2613 of 2016. Aisha Khatun versus Union of India. It was decided on 3/10/2016 itself. It is said that SOCOS, in the SOCOS notice, it is not necessary that everything has to be decided, my lord, written. And it should be given, or the ground should be given separately. If it is contained in the SOCOS notice itself, that will be enough. That is settled by the Honorable Court. And this has been reaffirmed recently, my lord, numbers of judgment. And this is another judgment of recent, where also it is affirmed on 17/9/2025 in WPC 3939 of 2021. And thirdly, my lord, with regard to my learned friend's argument, my lord, in the NRC, her name is appearing. So her seem to have a different, my lord, she should be declared as Indian and she has a right to appeal. That has been settled by the Abdul Quddus already. As your lordship has rightly pointed out, Abdul Quddus, it is clearly stated. It will be, my lord, if a foreigners tribunal declared a person to be foreigner, his name cannot be included in the NRC. That is also settled in this case also. And if it is somehow, my lord, entered, or my lord, his name is deleted from the NRC due to such, my lord, the my lord, declaration by the foreigners tribunal, he will have no right to appeal against that, my lord, order of NRC in the foreigners tribunal, which is to be set up after finalization of the NRC. So there is no appellate right. That has been settled. That is law also says, my lord, the para 8 of the, my lord, rule 2003 has said that it cannot.
Please repeat again.
My lord. So, my lord, in Abdul Quddus, it is clearly said, my lord.
Which paragraph of Abdul Quddus?
Your lordship will find. This is, my lord.
We will
My
break,
lord, para 11 and 12, 11 and 22. And this is another judgment of recent, my lord. If your lordship peruse this, it is Rafiqul Haq. This is by the Supreme Court again. 2025 0 SC 0 Supreme. 2025 0 Supreme SC 870. Criminal appeal number
SC
870, my lord. 0 Supreme.
which paragraph?
Para 27, my lord.
Please read that.
Para 27 says, in view of the decision of the court of Abdul Quddus, firstly, consequent to the declaration by the tribunal that appellant is a foreigner, the name of the appellant could not have been included in the draft NRC. And secondly, even if it has been included, it would not annul the declaration made by the tribunal. And pardon me, Malad, Abdul Quddus was for that purpose. Yes.
May I take indulgence of your lordship?
Yes, Mr. Raj.
Item number 18, my lord. This is a different matter, custodial, that at the hands of the police. So petitioner has filed petition for compensation. Today it is not likely to reach because your lordship is arriving at 3:30 or so. May I pray that it may be taken up day after tomorrow and liberty may be given to me for upgradation.
Okay. Just see and give it.
18. Any date, my lord.
Represent criminal. Just wait for some time. We'll check out the dates and give one.
You will give, I'll take it from him.
Ah, yes.
I will take the liberty to mention it on the date 22.
Definitely,
I'll not take
because-
much.
No, not that we take it up, but since these are
No, these are, I'll
work
take less
pending
time.
matters, we had to take it up.
No, it's not that. That I understand, mine is 18. Don't
So
make me
normally I
critical.
give priority to this WP criminal.
I know. Yes, yes. 18, WB.
It's okay, same thing. We'll just give a date after we raise,
I'll
we'll
take-
just take up and give the dates.
Keep you.
Just see that special bench is not there on the plate.
Your Lordship. I kindly see the Abdul Quddus at 2019 6 SCC, my lord. Where is 2019 6 SCC 604.
Which paragraph?
Para 29, madam. SCC, madam. Para 29.
Just a moment.
Merit.
Just a moment. How does it start?
Madam, in view of the opposite findings. Last part, madam.
Last part.
Last part. Part last para, madam. In view of the aforesaid findings.
In view of the aforesaid finding, yes,
Yes, madam.
page 93.
Yes, merit. In view of the aforesaid findings, it has to be held that para 8 of the schedule to the 2003 rules, which gives a right to appeal before the tribunal under 1964 order would apply only if and in those cases where the tribunal constituted under 1964 order has not already adjudicated upon and decided the issue as to whether the person is an Indian or foreigner. In other words, where the issue and question of nationality has already been determined under the 1964 order, an appeal would not be maintainable under the para 8 of the schedule to the 2003 rules. That's the determination would be final and the binding on the registering authority under the schedule and the local register. Para 8 does not in this case and provide for second round of litigation before the same authority, that is the Foreigners Tribunal, constituted under the 1964 order on and after preparation of the final list. Provisions of para 18 of the schedule of 2003 rules will apply when there has not been any earlier adjudication and decision by the Foreigners Tribunal. So that is the put. And that has been clearly in the last judgment, the 2005 SC or 870. I have referred already. Para 27 of that judgment, madam. Same thing has been clarified.
Rafiqul Haq.
Yes, Rafiqul Haq. There, in fact, it is said that once he has been declared foreigner, his name cannot be enlisted in the NRC. That is clarified. Because here it is said, consequence to the declaration by the tribunal, the appellant is a foreigner, the name of the appellant could not have been included in the NRC. The inclusion of the NRC itself is illegal, not correct. So the name included in the NRC cannot be a ground for my lord. Declaring him to be citizen.
How is that Rafiqul spelled in this judgment?
ROFI. ROFIQUL.
ROFIQ
UL.
QUL. Yes.
There also last, second last para.
Okay.
With regard to notice, I have already given a judgment. Probably your lordship has noted down. That is Aisha Khatun, WPC number 2613 of 2016. Decided on 3/10/2016.
WPC
WPC 2613 of 2016.
2016
Yes,
decided on
Aisha Khatun. Aisha Khatun.
decided on
Decided on 3/10/2016.
paragraph.
Paragraph, no, paragraph is not given here.
Okay.
It is started as first limit. And the same has been relied on, my lord, in another judgment, if your
This is
lord,
on what point?
my lord, decided on 3/10/2016.
It's on what point?
This is on, my lord, notice, what should contain in the notice, and whether the ground, how the ground should be, my lord, shown in the notice. Their simple point was that they pointed out that the grounds can be incorporated in the show cause notice itself. And show cause notice, it was mentioned that as per reference of the Supreme. So grounds can be included in the show cause notice itself. No separate grounds may be served with the proceeding matter. That was the point to be decided there. And that was relied on again in, my lord, there in para 22 of this judgment, my lord. This is Dukhumia, decided on WPC number 305 of 2016, madam.
What is
There
the name?
your lordship will find at para 21.
What is the name?
WPC 38045 2016, Dukhumia, madam. DUKHU. Dukhumia, MIAH. Decided on WPC 3805. 16, man. 3805 2016. There in para 21, my lord, it is clearly discussed. The earlier judgment has been relied. The same issue was also recently decided, my lord, because my learned friend was my lord, relying the Supreme Court judgment Sirajul Rohim Ali. The issue came up before the Honorable Court. And this Honorable Court has, in this case, my lord, WPC 3939/2020. WPC 3939/2020 decided on, my lord, 17/9/2025.
Name of the parties?
But is Iman Ali, my lord. IMAN. Iman Ali versus Union of India.
Paragraph.
Para, my lord, with regard to this para 10.
What does it say?
Para 10, my lord, issue of, my lord, the information given to the petitioner, whether those information given can be given to the petitioner while before at the time of, my lord, issuing notice. Then this honorable court has said that in fact there was some, my lord, error on the judgment. The quotation was wrong, my lord. The quotation that was finded, it was corrected later up on 1510, my lord. 1510, there is an order that has corrected. There it was held, my lord, the Sobananda Sunwal para 40, 41, 83 and 84 were not taken consideration while passing the judgment in the Supreme Court. So as per, because it is a larger bench judgment of the Honorable Apex Court, my lord, the Sobananda Sunwal. In para 40, it was said, in IMDT, there was requirement of furnishing these materials to the, my lord, by the investigation officer to the, my lord, court, to the tribunal. But Honorable Apex Court in Sobananda Sunwal para 41 40 says that these are ultra vires. This information cannot be provided either by the investigation officer or by any person to the government or to the, my lord, tribunal, because it is not possible on the part of the, my lord, investigation officer or any person who is doubting the citizenship of the person to collect whether the person has migrated from East Pakistan or not. When they have migrated, why they have migrated, they are not going to disclose all these things to any person because it is their personal. So this it is not necessary that all these things has to be provided before issuing notice to the petitioner. So on that, it is said the Supreme Court has in Sobananda Sunwal said these are ultra vires, these requirements are ultra vires, my lord. So because these were requirement in the IMDT. So this requirement is ultra vires. As such, the IMDT is set aside, and the foreigners to 1964 order has been brought back. So on that issue, para 10, later on corrected on 15/10/2025, that is given them. The issue of notice is also relied here, my lord, in para 12 in the said judgment. Lukumia. It was decided on, my lord, 8/3/2018. So those are the only point, my lord. So my humble submission is that, in fact, my lord, the tribunal has committed no wrong. And another aspect is there, in this case, probably my learned senior was not arguing that issue, my lord. There is an IA probably. No, IA probably. IA was against the passing of an order of this honorable court, my lord, where this honorable court has issued show cause notice to the petitioner, why contempt would not be drawn against him for, my lord, be giving a false statement that his father was there in 1966 and 70, and later on, when inquiry is found, it was not father, it was some other person. So for that manipulation, that probably my learned friend will argue that it may be closed. That is, I'm not on merit because probably how much that inquiry can be accepted. That is another aspect, but this honorable court has passed an order. Let me also be look into that. That is apart from the merit of the case. Once if that order is not recalled, that will remain probable. My learned friend has come with IA, and IA, the order is there, mother. Order dated, my lord, 25/8/2023. The petitioner show cause as to why appropriate contempt proceedings or any other proceedings shall not be initiated against her.
before we read this, those provisions may not be attracted for a simple reason that under the requirement of the Assam Births and Deaths Registrations Act, for a delayed certificate, there's a requirement to have a magisterial order. This magisterial order is always normally reflected in the certificate itself. Because otherwise, it couldn't be issued. Can we put you a query? Can we put you a query? You see, come to paragraph 7 of your affidavit, filed in 23. No, your affidavit. Filed in 2023. Yes. You got it? Now, in this paragraph 7, you have introduced annexure J. Right? Now come to paragraph 11. This paragraph 7 is true to your true to the matters of record, which is true to your information derived from record. Correct. And this annexure J is the inquiry report. So you are saying on oath that you believe its content to be true. What more do we require? Paragraph 7, being matters of record, are true to my information derived therefrom, which you believe to be true. Therefore, the inquiry report is true. It is vetted by you. Two to eight. Matters of record. No, 2 to 8. In our copy, it is 2 to 8. If it is 6 in yours, then again, we can only congratulate you. Look at this. No, be satisfied. As a counsel, I don't want you to be going out dissatisfied. 2 to 8. Whatever be, nomenclature doesn't matter to me. I told you I have a weak memory. I remember only what I require. No, everybody who's practicing is a student. That's why we say practicing lawyer, we said practicing doctor. You may make a mistake. But the point is that you have proved the contents of that document to be true. There lies the problem. Police says that it is manipulated, and you say contents are true. We both have been trained in a very wrong place. Foundation is with the trial court. I have a habit of reading affidavits first, verification first, and then I come to this. Okay. We'll see this. This IA, Mr. Payang,
issued, my lord. Contempt is not drawn. Only show cause was issued, probably so. Yes. No, I'm not pressing, my lord. It is the petition of my learned friend, my lord. That's right. I leave it to your lordship.
The petitioner and so for the respondents is concluded. Next paragraph. However, we take notice of the contents of the order dated 2/8/2023 passed by this court, whereby the inquiry report along with the enclosures were ordered to be kept in the custody of the court master. Full stop. Accordingly, the court master shall take a printout of the order dated 2/8/2023 and place the said inquiry report before the court. Next paragraph. This on 29/10/2025. For placement of the, for placing the said inquiry report before the court. The argument is concluded. This report is not before us. They'll have to make inquiries very clear.
Report is probably with us, my lord, because
Huh?
report was given to us on
No, we don't know because this says that it is with the court master.
what?
So
Maybe.
please make an inquiry. Maybe you are having it. We don't know.
We have a copy, my lord. We don't know whether it is
Huh?
there on. Original. 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 A court master to the timeline.
Oh, this is the original one.
Yes, please.
It's with you. Okay. Is it like tablet?
মই দিছিলো নেকি আমাক তেতিয়া কপি দিব
Learned Standing Council for the FT and Border Matters has produced a copy of inquiry report, which is referred to in the order dated 2/8/2023. Next para accordingly is matter is reserved for judgment. Okay, it's there. Is it important? Just. একটি বলবো। আমি পাঠক থেকে একটি বলবো। ঠিক, ইচ্ছা পাঠক। হুম, See.
Lord, the impending opinion at page, my lord, 47. Picture, my lord, type copy. My lord, the original copy, my lord, is started from page 52. Type, my lord, dated, the copy, my lord, 8 to 4 for linkage.
Which page is the opinion?
Opinion at page, my lord, 47, which is type copy, my lord. Is that? Yes, ma'am. Grandmother is. Grandfather. And the deportation of. Yes. Yes. of DW one and two, my lord, I did not connect, my lord, but the TTR, my lord, flag A is the evidence of petitioner and my lord, flag B is the evidence of father of the.
Yes, ma'am.
The father of the petitioner might not examine the petition. And because he exhibited as many as 6 numbers of documents, including the current information. From the government of the state. Yeah. Yeah. But documents are evidence of the written. And that's okay. What the okay. So let's say how could that obviously it might
Para 15, my lord, that the Gaubura village Kalgasia, namely A. Mannaf, issued to my daughter a Gaubura certificate showing linkage with me as her father and with her husband. That I have submitted the following documents. Exhibit, my lord. 3 documents. These are missing, my lord. But the Gaubura certificate he exhibited, that is, my lord, page 22, my lord. Gaubura certificate is there. My lord, page, my lord, 22, my lord. My lord, 23 is the original, my lord. Twenty-three page. No, my lord. My lord, by exhibit B, my lord, annexure B, exhibit B, my lord, page 17, my lord. This is the voter list of 1997. Where the parents of the petitioner, Shukur Ali and Lal Bhanu. And in oral deposition, my lord, he deposed that he was a regular voter from 1970, my lord. But the 1970 voter list, he could not, my lord, exhibit. But the NRC details of 1970, my lord, that has been submitted. '97. And he, my lord, he stated in his written evidence as well as in my lord, deposition, my lord, that he was a regular voter from 1970. Only, my lord, the 1970 voter list he could not, my lord, actually submit. But the NRC of 1970, that was submitted. Yes, my lord. And Shukur Ali was examined as DWT. And my lord, is 19, my lord. This is the certificate issued by the Secretary of Panchayat, my lord. This is also.
Hello. Yes, ma'am. Mary's. My lord, the opposite party is my daughter. I am not aware about her date of birth. Now her age is about 40 years. Now her about age, ma'am. This was in 16, my lord. Yes,
16, then
2311, 16.
about 14, that means about 14, huh?
About 50 years.
14 ধরলো। 6. Date of birth, year 1976.
Yeah.
Lord, if my lord, in 2016, his age is my lord, assumed to be my lord 40 or 41, then now these are the my lord, the Monoruddin, he is the grandfather, and Moziron Nessa at serial number my lord 328. She is the grandmother of the petitioner. And others are family members, my lord. Monoruddin, Nobiron, Nessa, my lord, perhaps Sengu Sheikh. Monoruddin, he is the grandfather. And then, my lord, this is the voter list of 1966, my lord. Her grandparents were there, my lord. Please, my lord, 16. Voter list of 1966. This is, my lord, exhibit A, my lord. My lord, at serial number 326, Monoruddin, son of Sengu Sheikh. He is the grandfather. And my lord, at serial number 328, Moziron Nessa, she is the grandmother. And next, my lord, the exhibit B, my lord, page 18. This is the voter list of 1997. The parents of the petitioner, my lord. Shukur Ali is the father who was examined as DW2, and Lal Bhanu, she is the mother, my lord. Although, my lord, the father had, my lord, voter list of 1970, my lord, that could not, my lord, execute. And my lord, page 19, my lord, this is the Gaon Panchayat certificate. Here, my lord, clearly mentioned, daughter of Shukur Ali, who was married to Qasim Ali. Qasim Ali is her husband. Next, my lord, page 21. My lord, वो कौन सा है पूरा? चलो वैसे। Chinese apology. My lord, page 21, my lord, the voter list of 2010. Again, my lord, Shukur Ali and Lal Bhanu, the parents of the petitioner. And next, my lord, the page 23, the Gaubura certificate. Issued in favor of the petitioner, my lord. This is exhibited documents, my lord. Page 23. Next. Next, my lord, page 24. Wait. My lord, page 24, my lord. This is the voter card, electoral photo identity card of DW2, my lord. This is only, my lord. This is also exhibited, my lord, exhibit F, my lord. This is Shokur Ali, son of Moniruddin. Father of the petitioner. DW2, my lord. And my lord, page 27. This is the, my lord, the NRC details, my lord, of 1970 of the father of the petitioner, Shukur Ali, my lord. Page 27. His name is there, my lord. DW2, my lord, himself, my lord, produce number of documents that he is a, my lord, the father of the OP, my lord, proceeding, and deposed as DW2. My lord, page 27, my lord, the NRC details, my lord. Vote year. 1970, my lord. Vote year 1970. My lord, this is not exhibited, my lord, but the voter card here, my lord, clearly shows that the DW2, my lord, the other documents are exhibited, my lord. Other documents are exhibited, my lord, the voter list of 1970, Only, my lord, this is because this is not exhibited. Only, my lord, only, my lord, I am.
Do you think that reading the, while listening to the argument, reading all the documents is an easy task?
My lord, I am only showing that he was a.
Only that, then we close the argument. If it is only to show us everything, then we close the argument. We don't need your assistance. Do we really need your assistance? Tell us.
Yes, maybe.
Then we would have been better off without your assistance. You have to tell us what the documents are. We are referring to the exhibited document. We are showing you the affidavit. It's not exhibited document. You're spending unnecessary time.
My lord, I am just showing that he was a voter. Honor before
Please don't
19
show us that. There are many things on earth which I don't know.
Yes.
And I don't have the energy to learn everything which is, every knowledge is there on earth. Stick to your brief.
My lord, my limited prayer is that, my lord, the petitioner exhibited the voter list of 1966, where her grandparents' name were there, my lord, and her father name.
You see, the
appeared-
difficulty is that you all you don't have energy to look at the LCR. You're just making arguments which is without any depth. You write in our evidence that the exhibit B is voter list of 1970, and that is not exhibited. The exhibited document is exhibit B is 1997. This discrepancy you don't tell us. You don't tell us because you don't read. You did not spend any time in looking at the trial court record. And it's a sheer wastage of time.
1997 is exhibited, my lord.
When you don't assist us, you don't expect what you call
And
anything from the court. You're just misleading us with some statement here and there. If you don't compare it with the records, what is the worth of your worth listening to you? Tell us what is what we have what we could follow in your argument so long. We followed nothing. None of the documents are exhibited. There's a big gap from 1966 to 1997.
yes, my lord.
Your case is already lost.
It is there, yes.
We're giving you time because it's an issue of citizenship and you don't assist us. You think that making statement here and there would help you. It doesn't help you. And you've seen that we have taken the records. Mr. Pang was reading it. We have called for the records. We are looking at it because things are not matching. When we read your evidence, when you read the judgment, it's not matching. We close the matter. Heard.
My lord,
Mr. S. A. Ahmed. No, we don't give you time for hearing. You are not prepared. We'll do it better. As Mr. S. A. Ahmed, learned counsel for the petitioner, is making unnecessary arguments, referring to unexhibited documents. We don't find any purpose to hear the learned counsel for the petitioner. Full stop. List on, we will make it list on Monday for submissions of the submissions of Mr. J of the learned standing counsel for the FT matters, who would also assist us in presenting the case of the petitioner. Mr. Pang, you made the order, you assist us in presenting the case of the petitioner.
Can
Whatever
it be on
is.
second, my lord?
Huh?
Monday, Tuesday, my lord.
Tuesday, okay, make it Tuesday. Tuesday we have 6 matters. Fine. If you want record, you can take it.
Yes.
The court master will provide the records to the tribunal, to the learned standing counsel for the FT matters. He'll assist us.
Yes.
We don't want your assistance.
One thing, my lord, may I allowed to, my lord, obtain a photocopy of the deposition?
Absolutely not.
One improvement.
Absolutely not. Photocopies of the records are not permitted. Have you read the High Court rules? It's not permitted. And we are not providing you with that.
Item number 4, my lord.
In item 4, Lordship has directed us to deposit 2 lakh rupees in the registry. Well, the sanction has come. Nowadays, one difficulty is that they have to deposit the amount in the account. They have to make the account transfer. They have asked for the account details.
Right now.
The account details of the registry. Lordship has directed to deposit us in the registry.
Registry, my lord.
So I have approached the registry. I have sent my colleague. They said that it is to be given in the demand draft. But the demand draft may take 1 or 2 days. Otherwise, if I get the account number, it can be deposited tomorrow.
I asked the registry. We'll inform you. We can inform you only tomorrow.
Lot.
Get this matter listed on Monday.
Lot. If I get the account number, it can be done in.
Just give a
in
copy of the
in a
letter to the postmaster and make an inquiry.
Lot.
I will provide my account number.
No, account number of the.
They're not asking for your account number. They say that they'll be deposited in court and from court you can take it.
Yes, lot.
So let's find it out. Because you see, the problem with the registry is that they will have to maintain the accounts. Wire transfer to the registry, they will not be able to locate that this has come from where. Because this is a government account. And therefore to track it and then earmark it is very, very difficult for the registry, but I'll find out. I don't have ready answers.
That is why I have indicated what I have approached the registry. They said it has to be in
I'll
the
make an
demand draft.
inquiry.
Demand draft. Then Lordship may
Must
indicate
be-
or will do that.
Monday, we'll get it.
Lordship, I have given the letter.
Okay.
Lordship.
Yes,
Problem.
in the next page.
No, in this case.
Oh, in this matter.
Lordship.
This is record the presence. Mr.
K. Koli.
K. Kalital, the petitioner, Mr. Dinar, Senior Government Advocate, along with Mr. H. K. Hazarika, Government Government Advocate, Mrs. S. Sharma, and standing counsel for the Health and Health Department. Mr.
Yes, it's now on paper of number 7.
Number 7. Is the number 27.
Oh, all right.
Division bench item 1 for orders.
We are concerned, we have seen it, we don't have any queries. If you want to add anything or subtract anything,
Well, there are, my lord, in the FIR, my lord, there are 3 accused, my lord. The other accused, my lord, that is, my lord, Zayed Khan and one another person, they have been enlarged on bail, my lord, by this honorable court.
Yes.
That order I'm just placing, my lord. And my submission, my lord, in 1 minute, my lord, Article 21 of the Constitution of India, my personal liberty cannot be curtailed without following the procedure established by law. Well, there is a slight difference between procedure established by law and the due process of law, my lord. So in this case, my lord, Constitution says, my lord, the due procedure of law should be followed. So as per CRPC, section 50 and 50A, now 47 and 48 of the BNSS should be followed.
that you have made your.
Then that is my submission. And secondly, my lord, I should point out to this court, my lord, for once, my lord, page 17 of my petition, my lord. Page 17, my lord, it is the memorandum of arrest, my lord. So as per the CRPC, my lord, the memorandum of arrest should be attested by a witness, my lord. In the instant case, my lord, it has not been attested by any witness.
So therefore, this memorandum of arrest cannot be, my lord, held to be a memorandum of arrest in the eye of law, my lord. That, my lord, I am referring to, my lord, section 41B of CRPC. 41 capital B of the CRPC. Hmm. 41B, my lord, it says. My lord, B, my lord, prepare a memorandum of arrest which shall be attested by at least one witness who is a member of the family of the person arrested or a respectable member of the locality where the arrest is made. And my lord, thereafter, my lord, 60 capital of the CRPC, my lord. No arrest shall be made except in accordance with the provision of this Sanhita or the CRP code or any other law for the time being in force, providing for arrest. That much. And the case law already I have furnished, my lord.
Any authoritative pronouncement on the 41D that if it is not attested, it becomes.
I have not found. I tried my best, my lord. I have not found, my lord.
Okay.
Because this
So
point.
this is something which is not covered
Yes, my lord.
by the provisions of 461 CRPC.
My lord.
That's why I just put that.
My
for you.
lord, that
Okay.
I could not find, my lord. And all the authorities I have given, my lord, before your lordship, my lord. And one more, I think I have given, my lord, I couldn't check the file, my lord. One judgment of our division bench, my lord, Justice Michael Juthan Kumar, my lord. My lord, the question arises, my lord, if a judgment is passed by a co-equal judges of the Supreme Court, my lord. So now there is a division bench judgment after this Vihan Kumar. One judgment was passed, my lord, that a famous actor of South India, my lord, Darshan, my lord. I think my friend will rely upon that, my lord. Darshan's case, my lord. So our honorable court division bench has held, my lord, relying that, my lord, Supreme Court's constitutional bench judgment, that the earlier judgment will prevail, my lord. But just. It's, my lord, National Investigating Agency versus, my lord, one Mete, my lord. If it is not there, my lord, I will provide the same, my lord, during the course of the day.
That is here. We have-
It's just there, my lord. My lord, that Supreme Court's, my lord, Pranay Shetty's judgment has been relied upon, my lord. That much, my lord.
Yes.
The first I want to place the post title of the application filed by the petitioner. In terms of habeas corpus, the file bill application, fortunately to see the post title, page 1.
Yes.
Merit. An application under Article 226 of the Constitution of India, time for issuance of writ in the nature of habeas corpus. Directly may come from authority to release the accused person who is behind the bar since 30/10/2020. Now, Lordship, pray, page 12.
Yes.
In the aforesaid promise, it is therefore prayed that your lordship will please to call for records in connection with NDPS case number 12 of 2025
corresponding to HP Kerala Kachanshu or extra data section 49. The NTPS said, then we put another code from the learned speak and judge Kamru Guwahati. And after the revision of the two reports and after hearing the parties, your lordship would be pleased to issue within the nature of addendum with a direction to release the equivalent petition on the page. Lordship seen that post title in garb of habeas corpus rape by the application. Now there
Because in the next page, page 2, they say it's a violation of fundamental rights.
Lordship, that is correct. But Lordship, post title and the prayer, there is a difference between two. They file application for habeas corpus and the prayer is to release the accused person on bail. The basic their contention is Lordship to release the petition on bail. And their contention is that some mandatory provision of CRPC has not been followed. Lordship, not vesting Lordship, it is honorable court. Already decided the issue. So, is also relating to bill, same question was raised before the Honorable Sundar. And this court is, after considering the, all the aspect of the matter, rejected the bill.
Yes.
This aspect of the matter is already been dealt by the Honorable Court, the titular state.
Which paragraph you're referring to?
Paragraph 15 or what?
Yes.
I'm not sick for simply, no, Supreme Court in case of serious that's paragraph 20. Paragraph 20.1. Page 18. Suppose the Bihan Kumar Supreme Court says that it is mandatory to furnish the ground of arrest. In Bihan Kumar case, it is already known that Supreme Court held that the ground of arrest is required to be specific ground of required to be supplied to the equipment. But if here, this is judgment lordship, all the judgment has been taken.
With this period on, I have.
Well, Lord, I'm sorry. Lordship, in case of Bihan Kumar, Supreme Court held that the provision of CRPC is to be followed meticulously. But in this case, Lordship, Supreme Court has considered all the judgments passed by the Supreme Court earlier that has been taken into consideration. Paragraph 20.1.
delay in furnishing ground of arrest cannot be itself constitute a valid ground for grant of bail. Lordship may come to paragraph 20.1.4, page 18. In Bihan Kumar versus State of Haryana 25 so and so, it was reiterated that the Article 22(1) is satisfied if the accused is made aware of the ground of arrest in substance, even if not conveyed in writing. Similarly, in case of Kesareddy Upendra Reddy versus State of Andhra Pradesh, it was observed that when arrest is made pursuant to a warrant, reading out a warrant amounts to sufficient compliance. Both these post Pankaj Bansal decision clarify that the retained individualized ground are not an inflexible requirement in all circumstances. While section 50 of CRPC is mandatory, the consistent judicial approach has to be adopted a prejudicial oriented test when examining alleged procedural lapse. The mere absence of retained grounds does not expecto render arrest illegal unless its result demonstrable prejudice or denial of fair opportunity to defend. Then paragraph 20.1.6. The High Court, however, relied heavily on the alleged procedural lapse as a determinative factor while overlooking the gravity of the offence under section 302 IPC and existence of prima facie case. It does not inter alia that there was no mention in the remand order about service of memo of ground of arrest, para 45, and arrest memos were allegedly template based, not personalized. Paragraph 20.1.6.
Yes.
I am again reading. The High Court, however, relied heavily on the alleged procedural lapse as a determinative factor while overlooking the gravity of the offence under section 302 IPC and that the existence of prima facie case. It noted inter alia that there was no mention in the remand order about service of memo of ground of arrest and arrest memo were allegedly template based and not personalized by eyewitness, had not stated that they were present at the time of arrest or had signed memos. Relying on Pankaj Bansal, Union of India, and Parvi Prakash, so and so, it is concluded that from 3/10/2023 onward, failure to serve detailed, written, and individualized ground of arrest immediately after arrest was a violative entitling the accused to bail. Paragraph 20.1.7. In the present case, the arrest memo and the remand orders clearly reflects that the respondents were aware about the reason for the arrest. They were legally represented from outset and applied for bail shortly after arrest, evidencing an immediate and informed understanding of acquisition. No material has been placed on record to establish that any prejudice was caused due to alleged procedural lapse. In absence of demonstrable prejudice, such an irregularity is at best a curable defect and cannot be itself warrant release of the accused on bail. As reiterated about the High Court, treated in the determinative factor while overlooking the gravity of charge under section 302 IPC, existence of prima facie case, it relies on Pankaj Bansal and Parvi Prakash is misplaced as those decisions turn on materially different facts and statutory context. The approach adopted here is inconsistent with the settled principle that procedural lapse in furnishing ground of arrest absent prejudice do not expect to render custody illegal and entitle the accused to bail. Now, Lordship, our High Court in division bench passed an order holding that the earlier judgment will prevail based on a judgment of Supreme Court. Lordship, I want to place that judgment also. Although it was a constitutional. Relying on paragraph 30 of the judgment, with respectfully, I submit that Lordship, the mandate of constitutional bench is quite different. Probably that was not properly placed, so this judgment was passed. Lordship, come to directly come to
This
paragraph
order
30.
you have not challenged.
Lordship,
The division bench order of this court is not under challenge.
that was passed in by the in the case of National Investigation Agency. Lordship, I am placing Lordship may consider if I have some ground. Lordship, paragraph 30, page 11. Lordship, that was not
Yes,
properly
paragraph
considered.
30.
Lordship, yes. That relying on that judgment, our High Court division bench held that earlier judgment will prevail. Lordship, there is a basic difference. Because in case of subsequent judgment, all the previous judgment is taken into consideration, including the Bihan Kumar Lordship. And this is not a case of per incorium Lordship judgment. Lordship, here paragraph 30. Page 11.
Page 30, paragraph 30.
No, paragraph 30. Paragraph 30.
Yes.
In this context, we may also refer to Sandeep Kumar Bafna versus State of Maharashtra and another so which correctly lays down the principle that discipline demanded by a procedure precedent or a disqualification or diminution of a decision on the application of per incorium rule is of great importance, since without it certainly of law consistency of the ruling and committing the courts would become costly casualty. A decision or judgment can be per incorium any position in a statute, rules or regulation which was not brought to the notice of the court. The decision or judgment can also be per incorium if it is not possible to reconcile its ratio with that of the previous judgments of the co-equal or larger bench. There can be no scintilla of doubts that a earlier decision of co-equal bench binds the bench of the same strength, though the judgment in Rajesh's case was delivered on a later date. It has not appraised itself the law stated in Reshma Kumari Supra, but had also been guided by Santosh Devi Supra. We had no hesitation that it is not binding precedent on the co-equal bench. Lordship, after reading this paragraph, what I understand that earlier judgment has not been placed before the subsequent bench. If the judgment is per incorium, then in that case, Lordship, earlier judgment will prevail. But here in this case, Lordship, in Darshan's case, all the previous judgment is taken into consideration. Lordship, I have prepared a note for consideration of Lordship. And Lordship, recently Supreme Court, in one of the case, it could be. Good, you know. Paragraph 25. Paragraph 2 Lordship, in Tahsildar's case, which I have given, Lordship, paragraph 35. Andhra Pradesh Electricity Board versus Tahsildar law. Paragraph 35.
No, this order which is placed before us is Anar Ali.
No, he has wrongly given. I'm sorry, ma'am. There is a single bench judgment, my lord. That point, my learned friend, which has raised, my lord, regarding Darshan and that, my lord. that has been dealt, my lord. That is only for persuasive in nature, my lord. I'm not saying that is a binding upon your lordship.
You are reading which paragraph?
Paragraph 35 of Tahsildar's case.
Tahsildar,
Lordship,
okay,
paragraph 35.
35.
Lordship.
Check your
May I read, Lordship?
Yes.
If two decisions of this court appears inconsistent with each other, the high courts are not allowed to follow one and overlook the other, but should try to reconcile and respect them both, and the only way to do so is to adopt the wise suggestions of Lord Halsbury given in Queen versus so-and-so and reiterated by Privy Council so-and-so. Every judgment must be read as applicable to the particular facts provided, proved, and assumed to be proved, since the generality of the expression which may be found there and not intended to be exposition of the whole law, but govern a qualified by particular facts of each case in such expressions are to be found and follow the decision whose facts appear more accord with those of the case in at hand. Lordship, here, Lordship seen that the Darshan's case, all the previous judgment has been taken into consideration. We cannot say this is a Parveen Korean practice. Bihan Kumar, Bansal, Parveen, because all the previous judgments pronounced on basis on the supply of the ground of arrest and others has been taken into consideration. And Lordship, the another division bench probably has not properly held that has not considered the constitutional bench judgment in proper perspective. In paragraph 30, I placed before this honorable court, which clearly says that if the judgment is Parveen Karim, in that case, Lordship, then previous judgment will prevail. But here, Lordship, all aspects of the mandatory provision will be taken into consideration in case of Darshan's case. So with due respect, Lordship, I submit that the earlier judgment of this honorable court by division bench is not a correct law. In view of the different judgment placed before Lord. And the purpose of mandatory provision has been explained better in better way in the Sri Darshan's case. But see, this is a Bihan Kumar's judgment. And that was properly explained in Sri Darshan's case. All previous judgment, Bihar Kumar's, Pankaj Bansal, because all judgment will be considered. So it cannot be said that the Sri Darshan judgment was a Parveen Korean. In view of the not to consider a late judgment, but all the judgment will be considered. And the constitutional bench mandates that when there are two judgments, and Lordship, another thing, Lordship, there is no conflict between Bihan Kumar and Sri Darshan. It is better explained in the Sri Darshan's case. Even then, Lordship, we assume for the time being that it is a conflicting judgment. In that case also, subsequent judgment, because it is a more explained judgment and all the point has been taken into consideration. So that judgment will be prevail, Lordship. And further, Lordship, in this case.
Just a moment.
না মই এফিডেভিট পাইছো। Yes, Lordship, our affidavit page 53. Page 53, we file our affidavit by Anil Kushwaha, Lordship, on 38/2025.
My lord, page 18 of my petition, my lord. The notice under section 50 CRPC. No, if that notice, your lordship, that I have annexed.
It's page 53. Reply to contention of para 11, 12, 13. Voluntary statement of intercepted person, namely Mohammad Faris and Mohammad Jayed Khan, were recorded at NCB office wherein they admitted of being guilty of trafficking of heroin for monetary benefit. Based on the statement of both Mohammad Faris and Jayed Khan, supplier of the seized heroin, namely Yusuf Ali, habitual offender, was arrested during follow-up action. That based on the confidential statement and corroborative evidence, both Mohammad Faris and Jayed Khan were arrested on 29/10/23 with proper memorandum of arrest, case detail of compliance of under section 50 of CRPC. Intimation of both the persons were given to their relative on the same day. During the time of arrest, both the persons, Mohammad Jayed Khan and Mohammad Faris, their family members, relatives were residing at Manipur. Hence, it was not possible to give signature of their family members on the document. His name is Faris.
Mohammed Farish. MD.
Then Lordship, next paragraph, Mohammed Zaid Khan gave intimation to his arrested wife, namely Suhana, on her mobile number so and so. Then 5, Mohammed Faris gave intimation of his arrest to his wife, namely Yasmin, on her mobile number so and so. Letter for intimation of arrest of Mohammed Zaid Khan and Mohammed Faris were sent to their family members on the same day, that is on 29/10/2025. And the same letter were endorsed by the learned court during production of both the accused persons so and so. Letter of intimation of arrest of Mohammed Zaid Khan and Mohammed Faris were sent to their police station on the same day, that is on 29/10/25. During the time of arrest, both the accused persons, Zaid Khan and Mohammed Faris, their family members were residing in Manipur. Hence, it was not possible to put signature of their family members on the said document. However, both Zaid Khan and Mohammed Faris gave intimation of their arrest to their family members on mobile number on the same day. Lordship, in my father's submission, Lordship, the purpose of section 15 was to make aware the accused person of his ground of his arrest. Lordship, on 2 occasions they filed application, one before the trial court and second before dishonorable court. So it is not the case of the petitioner, they were not aware about the arrest. No, Lordship, but it has been explained by Lordship, what is the purpose of serving of the ground of arrest and arrest memo, Lordship? That has been explained in the Faris case by the Honorable Supreme Court, Lordship. In Mohammed Faris case, Sri Darshan's case. Paragraph 20.20, Lordship. What's in paragraph 20.1.7. The present case, the arrest memo and remand order clearly reflects 20.1.7. Please. Please, yeah. In present case, the arrest memo and remand order clearly reflects that the respondent were aware of the reason of for their arrest. They were legally represented from the outset and applied for bail shortly after arrest, evidencing an immediate and informed understanding of accusation. So this is the purpose of Lordship supply of ground of arrest and all. Notes. 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 Notes if it is filed on oath by the investigating officer. And the document says the next one will understand with his application. The documents which were that has been relied by my learned friend in his petition lordship, that has been annexed. And we make the statement on North Lord. Now lordship question arises whether which judgment is to be followed. Because our high court in division bench held that the earlier judgment will be followed. Lordship, that judgment is based on a constitutional bench. I have already referred paragraph 30. Probably that was not properly considered, Lordship. So this judgment was passed. Lordship, of my affidavit, Lordship. Lordship. Yes. Lordship, yes, Lordship, there is no paragraph. Lordship. Lordship, then I'll produce the record tomorrow. Lord. I'll produce the record tomorrow, Lord, because it is from what it said. Monday, Lordship.
এইটো কোন আছিলে জায়দালটো জায়দালটো
Notes. Yes, notes. I do agree, Lord. Notes that yes, it is not properly, yours it was filed hurriedly on the basis of the prepared by the IO itself. I do agree with Lordship, it was not properly drafted and
May I suggest, my lord, one thing, my lord? My lord, the records have already been submitted to the court, charge sheet case, my lord. And that record is available in our court, my lord. Because, my lord, in that case, I have furnished, my lord, bail application 1958, 2020, 1958. It is available, my lord. Although there is a disposed of case, my lord, the scan copy here. Now, only one point, my lord. Very, my lord, hairline difference, my lord. The Darshan's case and Vihan's case. Whether the Darshan's case overrides Vihan's case or not. Darshan's case, my lord, it says, my lord, that mere absence of written ground does not ipso facto render the arrest illegal unless in demonstrable prejudice or denial of a fair opportunity to defend. So I was arrested on 30/10/23. Whether I filed a bail application on that day or not. If the grounds of arrest, if they have supplied, my lord, I could have filed a bail application on 30/10. And if your lordship, my lord, pleases, my lord, that
two bail applications filed by them.
yes, I'm admitting. Yes. Man. But that's, my lord, for my satisfaction, my lord, I'm supplying this Anarali case, my lord. In that paragraph 25, my lord, three Darshans, now it has been taken back, my lord. Yes, ma'am. One is not 1958/25. 1958/2025. Muhammad Zayed Khan versus UI. That Anarali I have given, my lord, because the distinction of that, my lord, Darshan's case and Bihan case, paragraph 25, man. 1958. Madam. No, I have given one.
He is asking for calling of the record.
Record, my lord. The record is available in BA number 1958. 5. Disposed of on, my lord. 5 8 of 23/07/25.
Lots.
Okay, go ahead, hello, please.
Lots. No, I understand. Lots.
Bye. The judgments, my lord.
Lots.
Bye.
I'll make a compilation and I'll submit on that. Lots. I'll. That's I will make mention. Lots.
Man. Can I quote the paragraph, my lord, if your lordship permits it, my lord? My lord. I'm obliged, my lord.